Araszkiewicz. Okay, so he's going to tell us about conceptual structures in computational models of legal knowledge and in human minds. So he is an assistant professor in the Department of Legal Theory at the Jagiellonian University in Krakow, and he holds a PhD in legal theory. So he has, of course, published extensively in the field of legal theory and of AI and law, etc. But his specialization is in the theories of legal reasoning and argumentation, legal interpretation, case-based reasoning, normative aspects of AI, right to explanation, and all those things. So he's very well known in the community. So he's currently a member, secretary treasurer of the executive committee of the International Association for Artificial Intelligence and Law, and the steering committee of Juridical. So he also served as the president of the RGTF Association. And this is an NGO that is focused on the problems of argumentation, dialogue, and persuasion. He, has been very active in also co-organizing and been in the field for the numeric scientific events, Juridical 2014. He was a conference chair. And then the XILA, the Explainable and Responsible AI in Law, and the ICAIL 2021. So he's also a legal advisor and partner in the Michal Araszkiewicz law firm. Please excuse my pronunciation. I'm sure I'm not able to do it perfectly. And as we said, in the legal practice, he specializes in the field of legal regulation of AI, as well as in the intellectual property, data protection, protection of information, etc. So, I hand over the stage to him. So we will learn from him about this computational models of legal knowledge. The concepts are the most important concepts. And we learn about the conceptual structures. Thank you very much again for agreeing to be part of this. So over to you, Michal.
Thank you so much for this most kind invitation, and the pronunciation of Polish surnames is, of course, a different story. But you were really close, so congratulations. I will not dare to pronounce any Indian surnames. All right. Let me try to
please at least pronounce your name once, so that I know, I learn from next time. I know.
Let me kindly try to share my screen.
Sure.
So there's the presentation for today. Can you see the presentation now?
Yes, yes. If you can please make it full screen also, that will.
Yeah, I will try. I just need access to this option. Okay. All right, so let's crack right into this. My talk is entitled Conceptual Structures in Computational Models of Legal Knowledge in Human Minds. This is a broad outline of a project which, in my opinion, offers very interesting opportunities for further development of symbolic models of legal knowledge and reasoning, symbolic models that is making use of knowledge bases expressed in language or in other symbolic structures such as graphs. This type of approach brings full explainability to the functioning of the system, and moreover, it represents the structure of legal justification, the support of a legal conclusion by reasons which are considered good reasons in the community of lawyers. So let us begin with the question, what are concepts? This question is a tough one, because the term concept is ambiguous itself. Of course, we have an intuitive grasp of what the concept is. So here we can paradoxically begin our talk with a statement that we have more than one concept of a concept. And so the diversity of entities which are referred to by the term concept led some scholars, including Edward Maschery, to a suggestion that the term concept should be abandoned and that we should use more specific terms. Yet it seems that the term concept is useful as a kind of catch-up phrase, at least for the initiation of this discussion. Concepts are investigated in different research areas, such as traditional philosophy, philosophy of language, cognitive psychology. Here we have a few particularly influential theories of concepts, philosophy of mind, of course, artificial intelligence, and last but not least, jurisprudence. So the question emerges here whether there is something specific to legal concepts which makes them, in a sense, distinct from concepts that we encounter in different areas of discourse. Of course, we are not interested in trivial answers here, that we have same structures but different content. What we are interested in is to investigate whether there is something specific about structural aspects of concepts which are used in the field of law. So if we would like to gather some typical features which seem to be quite common to all entities which are referred to as concepts, and ignoring the issues of their ontology in the philosophical sense, that is the mode of being of concepts. What kind of beings, objects are they? We may say that concepts represent a degree of generality, so that they do not express individuals as individuals. Then, concepts typically enable certain types of inference. What types of inference are there depends on the type of concept we are talking about, and concepts enter into different relations with each other. So very often, characterization of any concept involves its relation to different concepts. What concepts are to be found in the domain of law? So there we can use different criteria of distinction here. First, we may apply a criterion of the domain of legal discourse we are interested in, and taking this into account, we may distinguish between legal philosophical concepts, legal theoretical concepts, concepts related to particular branches of law, or even specific regulations or parts thereof. Then we may distinguish different sets of concepts, taking into account the source from which they are extracted. In the field of law, a very important criterion here is that some concepts are derived from whatever is called the sources of law, and some concepts which are still called legal concepts are not. Then we might consider the degree of generality. We may say that some concepts are neutral with regard to domain to which they are applicable, and some of them are domain specific. They are not to be found outside of a particular domain we are interested in. and this relativity may be discussed in the context of a particular legal culture, like the legal culture of Anglo-American law, common law, continental law, Islamic law, and so on and so forth. Then within these families of legal systems, we may distinguish particular jurisdictions, inside of them branches of law. And finally, what will be particularly important for us today is that we may distinguish different types of legal concepts with regard to the structure. How are concepts represented in computational models of legal reasoning? This is an important context to begin our discussion about the structure of concepts, because apparently, at least symbolic, good old-fashioned artificial intelligence and law models of legal reasoning are very much interested in structure of legal knowledge. A very important methodological question when we are starting to work on any computational model of legal reasoning is, should concepts and what type of concepts be explicitly represented in the system, and if so, how they should be represented. Some answers and constraints on the answer are as follows. So practically, we should take into account only those concepts which make actual difference in the functioning of the system, because otherwise they would be quite redundant. The task which is to be performed by a particular model is also an important constraint, because it to a large extent determines the choice of the adopted knowledge representation tool. So for instance, if we are interested in representation of a syntactical structure of a particular regulation, then perhaps conceptual analysis, conceptual engineering is not that important for us. Here, a very important distinction between deep and shallow models should be mentioned. It was discussed, for instance, in a very known paper by Trevor Bench-Capon in 1989. While deep models aim at the reconstruction of some relatively general concepts which are not explicitly available in legal sources taken into consideration, shallow models rather tend to focus on the principle of isomorphism and faithfully represent what there is in the sources, without perhaps a further decomposition, with perhaps an important exception where such a decomposition is required for lack of ambiguity. But at some points, we may also be interested in sustaining this ambiguity. For instance, if we are creating a tool which is there to support legislators, to indicate that there is a problem in the regulation. So, if concepts are taken into account in the development of legal knowledge based system, there will be their function, irrespective of whether how we put the emphasis, will be to enable some type of inference. And some of these inferences will be domain neutral. Some of them will be, again, domain specific. Perhaps the most debated type of concepts that are discussed in the field of AI and law and which are deemed to be relatively domain neutral are the so-called Hochfeldian conceptions, contemporarily more often referred to as normative positions. So many authors ventured to classify different normative positions such as rights, duties, powers, immunities, and so forth. These normative positions, for instance, enable the representation of the so-called logical relations in the legislation, also with the technology of semantic web. This work has also played a role in the decomposition of certain relatively domain-specific concepts, such as ownership, which is a concept of a private law, which may be further decomposed as a bundle of claims, obligations, immunities, and powers. So, famously, Hochfeldian squares may be represented as follows. By the way, they also represent this relational character of particular concepts. So here, the solid lines represent the relation of being correlatives, while the dotted lines represent the relation of opposition. So if Thomas, for instance, has a right towards N to pay him 100 euros, it means through the correlative relation that N has a duty towards Thomas to pay him 100 euro. Of course, this is a very rudimentary representation. More robust theories have been developed. This inferential character of legal concepts has also been discussed in a somewhat different stream of research, this time informed by the work of another legal philosopher, namely Alf Ross, who famously introduced the so-called eliminativist theory of legal concepts. That according to this theory, the primary function of any legal concept is to enable inference, as in case of the notion of ownership, which in turn enables elimination of this concept from our knowledge base. Of course, it is not the final story. Ross's observation was quite right, but the diagnosis and the conclusions were perhaps too strong. What is important here is that this modeling emphasizes inferential character of concepts, suggesting that concepts as such may be not used significantly in our knowledge modeling, because in turn, what we need is a set of legal rules. Apparently distinct approach was taken in the field of legal ontology engineering, where concepts play a pivotal role in knowledge representation, and the focus is on the different types of relations between these concepts. So in ontology engineering in general, and in its application In the computational models of law, we distinguish between upper level ontologies or foundational ontologies, which are concerned with the most general concepts. So here we, on the left, we have a part of the knowledge modeled by a Dutch project, LRI Core. So we have a foundational ontology which encompasses such terms as physical concept, mental concept, physical object, and so on and so forth. On the bottom part of this slide, we can see a part of domain ontology, and the so-called core ontology provides connections between these two spheres. On the right, we can see a domain ontology developed by Garcia. This is a classification of copyrights. So perhaps the most exploited type of relations which are discussed in the field of legal ontology are that of being a kind of or being a subset of, which typically enables some kind of inference based on the inheritance of certain features from the from the more general categories to the more specific categories, because a more specific category, a subcategory, is a subcategory of a more general category on account of some identified feature overlap. So the as discussed by Giovanni Sartor, there are these two general approaches towards legal concepts. That is, legal concepts as inferential nodes, as we have seen already, and legal concepts as ontological categories. But these two fields are rather complementary rather than disjoint, precisely because ontologies, conceptual hierarchies, enable imported types of legal inference. Legal concepts are also represented in case-based reasoning models, and this is a particularly interesting field of investigation. Because the main motivation for the development of case-based reasoning models in the 1980s was that for some domains of law, it is very difficult to reconstruct rigid conceptual structures as this conceptual jurisprudence or a rigid set of rules enabling inference. So a paradigm initiated by Kevin Ashley's hypo system, developed under the supervision of Edwin Risland, is to account for such terms as trade secret, data of possession, for which it is very difficult to indicate a set of sufficient or necessary conditions, enabling us to infer that a particular object is an instance of a concept, such as trade secret or possession. And so what do these systems do? They index cases with binary factors or gradual scalable dimensions, the collections of which represent how a concept has been understood in the past case law. So factors or dimensions represent relatively general terms, which are in fact considered relevant for the sake of determination whether a particular object is an instance and exemplar of this more general concepts such as trade secret or possessions. The factors, the binary factors may be joint hierarchies. So we go from base level factors through a potentially huge huge number of intermediate factor steps to high level factors. Eventually we reach the level of the so-called issues, as discussed recently by Trevor Benchcape and Katie Atkinson. So the very understanding of concepts which are grasped by issues is then given by the sets of factors which are linked to them. The understanding of particular issues and the concepts that are represented in the final conclusions of judicial reasoning may also be subject to change over time. And here, an important jurisprudential reference is the work of Lord Levy, who analyzed how concepts are created, stabilized, and then like decomposed, eventually abandoned in the evolution of case law. And conceptual drift, change of internal structure of concepts has also been discussed by Edwina Risland. And more recently, in a very interesting Juridical paper co-authored by Trevor Benchcape and John Henderson. So let us summarize what we have discussed so far very briefly. So we have so concepts are being accounted in computational models of law and legal reasoning. There are a few approaches towards this. The main focus is on normative positions on the one hand, and open textured concepts in case-based reasoning on the other hand. Conceptual modeling may constrain the inference performed by the system. It may be done, for instance, by predefining attributes and value ranges, such as in a hypo system, where dimensions could be seen in attributes of cases. And concepts also enable inference through a system of rules which are derived from hierarchies or through comparison of sectors or sets of factors or their magnitudes. They can also enable inferences that are not backed by explicit legal sources, such as in case of normative positions, which enable us and the computational system to reason about the implied normative positions. Finally, conceptual modeling, this distributed conceptual modeling, one would say, which is typical for case-based reasoning, provides grounds for comparative evaluation. So, and here I would like to focus your attention on two very foundational aspects of legal reasoning that very often remain quite hidden or implicit in our analysis. So we either somehow enable an inference through a system of rules. These rules may, of course, be divisible, or and these rules are predefined, or we enable comparison, which may in turn lead us to the extraction of a set of rules. Now let us move on our attention to how human juridical minds work. A few important observations at the outset are that lawyers differ from laymen with regard to results drawn from legal sources. Legal sources are expressed in natural language. So how is that possible? Moreover, lawyers differ from their colleagues from different jurisdictions with regard to results drawn from the same legal sources. This is very apparent, for instance, in the jurisdictions in which one and the same regulation is adopted. We can also assume that in these jurisdictions, people speak the same language, yet they are going to draw different inferences from one and the same text. Lawyers. Finally, more experienced or educated lawyers differ with regard to these results drawn by them from the less educated and experienced lawyers. What mechanisms are responsible for that? Well, the generation of the result, for instance, a certain propositional attitude, say belief about the content of law, is called heuristic. It's the generation of the results. It can be analyzed on different levels, on the neurobiological level, on the level of unconscious fast processing through the fast system in the mind, which controls associations, similarities, and intuitive generalization. Also more defined heuristics we use in reasoning, like more extractable heuristics, rules of thumb, and finally the influence of higher level structures, higher level knowledge structures such as concepts. So if lawyers differ from laymen in the results that they generate from the same sources and descriptions of cases, then we might ask a legitimate question: what exactly is or should be acquired in a law school? I think that the answer to this question may be systematized in the following manner. So law school should give you a general, perhaps largely inconclusive, because not every lawyer has to become a legal philosopher. So, but a general view on what law is, and perhaps more conclusive perspective on the functions of law, like the coordinative function of law, or fairness-related function of law, coercive function of law. If you are a lawyer, you are aware of these functions. What is the basic cross-domain, domain-neutral conceptual scheme of jurisprudence, such as Hochfeldian the conceptions, but also different types of norms and so on and so forth? The basic understanding of the rule of law, of the standards that should be followed in a particular jurisdiction if it has an ambition to count as the one in which rule of law is honored. So here, what I have in mind is rule of law in broad sense, including understanding of human rights, and the domain-specific conceptual schemes, such as the conceptual scheme of civil law, criminal law, administrative law, and so on and so forth. These domain-specific conceptual schemes enable lawyers not only to draw conclusions from legal sources, but also to critically evaluate them. And last, but certainly not least, the methods of legal reasoning, such as statutory interpretation, such as analogizing from case to case, balancing values, constructing and assessing arguments. And what is very important here, the case law may also serve as the source of knowledge, not only about what factors are important for deciding certain issues, but also, for instance, how particular arguments should be used, were used, which were assessed as used improperly, what values are relevant, and how they should be balanced, and so on and so forth. All right, so what structures of concepts are to be found in cognitive science? Classical categories. They are mostly noted in the field of the cognitive analysis of deductive sciences. Classical categories as bundles of necessary and sufficient conditions. Then we have theories of prototypes and exemplars, which enable us that something is more or less typical instance of a particular concept. Then we have a theory of concepts, according to which concepts are themselves theories, that is, systematized sets of propositions which satisfy certain conditions. And finally, we have multi-structural theories or pluralistic theories, which argue that in many domains we are using those different structures in parallel. So it is not the case that one of them is better than the other. It's only the case that we use them to perform different tasks in different domains. And now let us consider how these insights may or observations may contribute to the discussion of one of the most notorious examples in the field of law. That is the vehicle in the park example. So let's assume that we have a rule according to which vehicles are prohibited from entering the public park. And of course, we can ask questions whether an ambulance with a patient on board, a toy car, an electric kick scooter, or a wheelchair may enter the public park. And a lot has been said with regard to this in legal theory and also in formal modeling of legal reasoning. So for instance, we could resolve these borderline cases through the application of previous cases or by balancing relevant values. But my question is perhaps more foundational. Namely, what in fact causes that a wheelchair does not count as vehicle? At least at the first sight, we might have doubts whether it should or not. What is the reason for the doubts we might have? What is the reason for the fact that we perhaps would consider that a Ford Fiesta with a diesel engine is a prototypical example of the concept of vehicle here? So if we are to adopt this conceptual structures approach to this problem, we can say more. So first, considering how we answer the question whether a given object is an instance of a given category, like a vehicle, depends on the very conceptual structure through which the category is represented in the first place. So whether it is a classical category, whether it is a prototypical category, whether it is a more robust knowledge representation entity, such as a theory of a vehicle. And this is what in fact takes place in the evolution of the case law. The content of a particular category may also be subject to change without a structural change, but a structural change is also possible. So, if vehicle would be accounted as a classical category, then anything falling outside of the predefined set of necessary and sufficient conditions would be classified as non-vehicle. That's obvious. Of course, this may remain in some. We may feel uneasy with this conclusion. And if this conclusion appears unacceptable for us as lawyers, we may do very different things. So our focus may be switched on the interpretation of the conditions. So we may, for instance, apply the teleological interpretation of the condition. The set of conditions may be subject to change. So this set may be restricted or expanded. But we can also state that the conceptual structure of a classical category is inapplicable to vehicles, and that we should use another structure, for instance, a prototypical one. And then we have a greater degree of argumentative freedom concerning the potential doubtful cases. We can also make a conceptual change in some other region of the net of our concepts, such as we may concede that there exists more than one type of legal norms, and that our understanding of legal rules, such as this prohibition, should always be mitigated or constrained by paramount legal principles. Even the very concept of law may be debated, and we witness a debate of this type in very important historical moments, such as in Nuremberg trial or the trial of shooters at the wall after Eastern Germany regained independence. All right, so just very briefly, how these conceptual structures may be identified. There are linguistic indicators in a case law and in legal doctrine which enable us to do so. So for instance, we may find indicators for sufficient condition conceptual structures, also negative conclusions. We can particularly useful are, one would say, metastructural considerations, like where the court states that one cannot provide any exhaustive set of conditions to conclude whether a speech is an instance of a libel, or if they claim that the purpose of image building, and only this purpose, is a condition to state that an expensive cost of representation. Then on this higher level of a potential for it should not be accepted. The legal concepts, as all concepts, come in large structures referred to as nets, and there are some high-level legal or juridical concepts which the understanding of which is correlated with each other, like extensive interpretation and analogy, willfulness of act and being at fault, or protecting of acquired rights and the statutes. So can rights be acquired only through the statutory regulation in the continental legal tradition, maybe also through the sub-statutory legal documents. Final point is that the concepts are subject to variations, that the sets of conditions may be determined in a case law, or the sets of conditions of application of a particular concepts may be determined, or to the contrary, opened in the evolution in case law. The very scope of conditions may also be extended or restricted. The contrastive backgrounds that are used to enable comparison may be reinforced, stabilized, or modified. And finally, the courts may indicate that the certain cases are prototypical for the application of certain concepts, or deny the existence thereof. What challenges for AI and law research follow from this approach? So to work on pinpointing these linguistic indicators is, of course, a very tedious one due to linguistic variety, different styles of rationales of judicial decisions in different jurisdictions. But as this is a markup process, it may be automated to a large extent. Then, if you are discussing conceptual nets in the field of law, there is a question: what should be the point of departure, of entry for our discussion here? Basic commonsensical conceptual nets, and then perhaps we should focus on the simulation of legal education process by an algorithm, trying to indicate in what manner this commonsensical conceptual net is subject to change. Then conceptual variations, that is, variations within the concepts themselves. If we want to perform such variations, we need to have some predefined space for these variations. And here the role of commonsensical knowledge is paramount again. Moreover, our system should be vested with some understanding of the functions of particular domains of legal discourse. Many thanks for your kind attention.
Thank you very much. So questions from either the panelists or the attendees? I think Professor Bench Kapon, you had a question, so you can please ask. Hello.
No, I didn't have a question. I didn't have a question. I just wondered how I should ask if I did have them.
Okay. So any questions or comments, please? No.
So I suppose, first of all, hello, Trevor. So great to hear you. I would appreciate if you could type your question in the chat box, and I will be more than happy to answer you.
All right. So even the attendees, if you have any question, you may please type it in the Q&A box. In the meanwhile, I have a question. So this is a very interesting thing what you are saying, that how to define essentially, I mean, a vehicle towards the end of it, and so that I mean, there is an intention that why a vehicle cannot enter a public park, but then there are these exceptions like ambulance and all those things. So how to define it? Now this definition, when you say that this is 20 kilometers or whatever parking, that is based on a particular setting, right? For example, in a public park. But similarly, if you change the setting, maybe in a public gathering on a road. So how does that concept net or the concepts accommodate itself to different settings?
Yes, so this was, I believe, the last, this concerns the last point I have indicated, namely the understanding of the social context to which particular branches of law and institutions are applied, because the transportation rules which are applied on express roads have different purpose than rules which are applicable public parks, because like there is a different social setting. We have to take into account the purpose of the public park and the environmental considerations and so on and so forth. So yes, this is a very complicated problem of contextual dependence, but and precisely this differing context may lead to a motivation on the psychological level and to the development of the reason on the justificatory level, that perhaps we should modify the concept of vehicle. Of course, here we are discussing a very rudimentary case in which we have only this one rule, right? In major, in contemporary legal systems, so these examples sound quite artificial. However, the regulation ends at certain points, and then we have very similar discussions, however, concerning different objects, maybe new ones, such as tokens. So nowadays in Poland, we have a huge discussion about how the token trade should be regulated, what practices should be considered legal or illegal. So in a way, it's the stage of this rudimentary public park rule, but in a different context. But even so, so we might think that this rule, according to which anything that drives faster than 20 kilometers per hour counts as a vehicle, is a good rule for the context of a public park, because anyone driving faster than that would be very dangerous to the people in the park. But still, we may have some doubts with regard to this ambulance, right? And if this was the sole rule, structurally interpreted as the necessary and sufficient rule, then perhaps the ambulance drivers would not risk going through the public park in our rudimentary legal system, especially if the fines and other penalties were high. This may sound very counterintuitive in like democratic countries in the rule of law, but in fact, very similar rules were in fact present in authoritarian communistic regimes, where, for instance, people were obligated to return like all crops to the collective rural hub. I don't even know if there is perhaps there is a direct counterpart of this in English, but this is a kind of like a collective institution which belongs to a state where the agriculture is being cultivated. And they could not use any of these crops, even for the sake of saving someone's lives. So they didn't, because the risk was too high. Of course, it's morally abhorrent, but this is a different story. This shows that this very simplistic conceptual structure was applied there, because the communists, well, they were concerned about the effectiveness and the predictability of this regulation. So if implicit exceptions were introduced in the development of the case law, it would perhaps lead to like desanctioning this type of behavior, which was not their aim. And very often we have similar rules also in contemporary democratic legal systems. Perhaps they are not that morally abhorrent, but because they serve the values we believe in. But for instance, the financial markets or banking, they are regulated to an extreme level, with these sets of necessary and sufficient conditions. Why? Because we think in modern society that financial markets and banking are these spheres that we actually need this predictability, and that there should be no like loophole through which certain rules could be made more and more open to exceptions.
Thank you. Okay, so that's I mean, yeah, that's actually, yeah, right. So so good insights to this, right? So I mean, waiting for any other questions from the audience. If not, then in the interest of time, we may please thank the speaker again. It was very nice. Many new concepts about concepts itself and what does concepts mean, and legal framework and how things change in the context and all those things. So thank you very much for this session, and I guess we can yeah, so as we can see, yes, a very interesting presentation. Thank you. Yes, so all right, then should we close the session? If anybody else has a question, we have 2 minutes of time left, so but we can still have a question.
Thank you very much, Arnab. So if I understand well, we are now moving to a private session, yes. Right? Right. Yes. Thank you.
Thank you.
Thank you. Bye.
Bye. Thank you then. Okay.